Oh, yes!
There are two waves.
Wait, call who's the groupie
It's
outside?
locked out for now.
Emily.
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 Oh, Emily's great.
It's just Emily.
Hi, group eight.
There we go.
0 seconds.
Okay.
Okay, do we have to do call?
No,
Yeah, Cole!
this is our top today. Is anyone recording this?
I am.
Did you tell them to? Is this a setup?
Yeah, no,
40 times worse. Okay.
Now that awkward first slide was
Okay.
just
You're gonna
silence
hit
for
play.
15
Not
seconds.
there. Okay.
Miss Byer, Mr. Byer.
Ingraham versus Wright. And it's by me, Cole Schmitz, and basically has to do with like students' rights and like how they felt violated by their rights. So the question asked is, does the cruel and unusual punishments clause of the 8th Amendment apply to disciplinary corporal punishments in public schools? And apparently it does not. Yeah, we'll find out why. So who was involved? James Ingraham and Roosevelt Andrews were the petitioners, and the respondents were Willie J. Wright, Lemmy Dillyford, Solomon Barnes, and Edward L. Wigman. Those were the respondents. They're like the yeah. So it was argued on November 2nd and 3rd, 1976, and decided on April 19th, 1977. And it was at Charles R. Drew Junior High School in Dade County, Florida. It's like right there, like Miami. So Ingraham was in 8th grade, and Andrews was in 9th grade, and they refused to leave the auditorium one day, and they refused to be paddled by the teachers, so the principal beat them with excessive force. Ingraham was given 20 whacks of a paddle instead of 5, causing him to miss 11 days of school because of a hematoma. And several students were being paddled so severely and excessively for breaking minor school rules, so they were missing school. So in 1970, Florida law allowed corporal punishment with paddles to be used to discipline students, and the paddles were required to be flat and 2 feet long, 4 inches wide, and about a half-inch thick. And teachers were able to hit students 5 times in their tuchus. Ingraham went to the United States District Court of Southern District of Florida. The district court dismissed all counts for hearing any evidence, so also he then took it to the Court of Appeals. And, the Court of Appeals reversed the district's court's decision, saying that the corporal punishment actually was severe and repressive and violated the 8th and 14th Amendment. And yeah, he's getting hit in the tuchus. During the rehearing of the case, the entire bench of judges, like normally just a couple of them would do it, but they rejected the Court of Appeals' decision and reaffirmed the decision of the judgment of the district court. So then he went and took it to the Supreme Court, and the judge there pointed that the 8th Amendment's ban on cruel and unusual punishment had always been applied to punishment of convicted criminals, so it did not apply to this case because it was school discipline and it was not criminal. So though corporal punishment did not violate any human rights, according to the Supreme Court, schools must abide by paddling regulations and not use excessive force. So they felt they were violated of their 8th Amendment, which was protection from cruel and unusual punishment, and the 14th Amendment was pretty much just forbade the states to restrict the students or the citizens' rights. The right to a cruel and unusual punishment varied from state to state. Each state was given the power to decide if corporal punishment is allowed. The states in Alabama, Texas, and Tennessee are just a couple of the 20 that used to allow corporal punishment. And each state that allows corporal punishment is kept in check by rules for punishment. Schools must only hit the student in certain areas, tuchus, and mostly, and a certain amount of times, 5 times. And the judge was Justice Lewis Powell, and he delivered the majority decision of a 5-4 decision in favor of the respondents are Wright, and that's him. That's justice. Okay. So today, corporal punishment is allowed in schools in 19 states and is limited by common law, and is significant for the Supreme Court to make all states connect with the amendments of the United States. Similar case is the Vernonia School District versus Acton, and that was like another student rights case, and the James Acton wasn't allowed to play football because he refused to let the school give him mandatory drug testing, and the Supreme Court decided in favor of the Vernonia School District in a 6-3 ruling, but it didn't mean that any random drug test to a student was constitutional. So